I am a child and I want to move out of my mother's house to my father's. Does this affect my mother and father's divorce settlement in court? Well, I believe your question is really something like this. If your parents' divorce settlement and the resulting court order based upon that settlement agreement provides that sole or primary physical custody of you was awarded to your mother, and you no longer want to be in the sole or primary physical custody of your mother and want to live instead solely or primarily with your father, then if you move out of your mother's house to your father's, contrary to the agreement or court order, what effect, if any, could or would this have on the divorce case, the child custody and child support award, and on you and your parents? I will answer those questions. In Utah, where I practice divorce and family law, child support follows the child. That means that the custodial parent receives the payment of child support from the non-custodial parent. This does not necessarily mean, however, that whichever parent the child may quote-unquote choose to reside with is automatically entitled to receive child support from the parent with whom the child chooses not to reside with. But the law also recognizes that there is no point and no fairness in having a parent who was quote-unquote awarded custody of the child to receive child support if that child does not in fact reside with that quote-unquote custodial parent. So if you are the non-custodial parent and your child says, "Mom or Dad, I refuse to reside with the court-ordered custodial parent anymore, and I am going to live with you now," that does not mean that your child support obligation suddenly and automatically terminates if you are the non-custodial parent. If you want to be recognized by the court as the custodial parent so that you stop paying child support as a consequence, in Utah you must file with the court a petition to modify the child custody and child support awards to be sure. And just because a child refuses to reside with the court-ordered custodial parent does not mean you will necessarily win your petition to modify the child custody and child support awards if the difference and the change in custody would not be found to be in the child's best interest. You would still have to prove that a modification of the child custody and child support awards would be in the best interest of the child. Also be aware that if you, the child, refuse to reside with the court-ordered custodial parent, the court-ordered custodial parent could try to blame the non-custodial parent, even though he or she did nothing wrong, and falsely report him or her to the police for kidnapping or custodial interference. The custodial parent could request a writ of assistance from the court permitting law enforcement officers to enter the non-custodial parent's home or car or any other location where you are and forcibly remove you from that place and restore custody of you to the other parent, at least until you run away back to the non-custodial parent's home again. But if you think that's a working solution, an ungovernable child could also be placed into state custody as well for refusing to comply with the court-ordered custody schedule. So the non-custodial parent will need to ensure that nothing he or she does constitutes those crimes, so will the child, and all of you will need to ensure that the non-custodial parent quickly files a petition to modify the child custody and child support awards if you want to make sure that's done properly and with the least amount of imposition.